Patrick Roark was supposed to face a major decision in court today. And yet, as of now, there's no arrest record, no booking confirmation, no public custody update, no verified report of him being taken back to jail. Instead, something else appeared. A new court date. Another probation revocation and contempt hearing is now scheduled for Tuesday, March 3rd at 1:45 p.m. in Raleigh County. That changes the timeline, because this wasn't supposed to roll forward quietly. The expectation going into today was that Judge Keith Compton would decide whether Patrick's probation would be revoked immediately, potentially activating the one-year suspended sentence handed down on July 21st, 2025. But instead of a clear outcome, we now have a continuation. Let's slow this down and look at what likely happened. First, there is no visible booking entry showing Patrick was taken into custody today. That strongly suggests one of two possibilities. The hearing was continued or rescheduled. The judge chose not to revoke probation immediately and set a future review date. Now here's where it gets interesting. The new date, March 3rd, is just 3 days before his separate felony case appearance on March 6th. That means Patrick is now scheduled to appear in court twice in the same week. March 3rd, probation revocation and contempt. March 6th, hearing related to the 11 felony charges. That proximity is not random. Courts often align hearings strategically when multiple cases overlap. Let's revisit the structure of the probation case. On July 21st, 2025, Patrick received 1 year of unsupervised probation and a 1-year jail sentence that was suspended. That suspended sentence remains hanging over him until July 21st, 2026. If probation is revoked, that sentence can be activated. The revocation appears to be connected to two potential issues. The 11 new felony charges filed while he was on probation, a notice of delinquency that was served regarding unpaid fines. Now let's talk about that delinquency notice. On January 16th, 2026, Patrick was arrested on the felony case. On January 22nd, while still in custody, he was served a notice of delinquency. That timing matters. The fine from his July 2025 case was $882.37. For months, it remained unpaid. If you count approximately 6 months from the sentencing date, July 21st, 2025, you land almost exactly on late January 2026. That suggests he may have been given 6 months to pay the fine. If that's accurate, the delinquency notice would have been triggered automatically when the payment deadline passed. And what happened next? On February 10th, he was served with notice of the probation revocation and contempt hearing. On February 11th, the very next day, the fine was paid in full. The balance dropped to 0. That sequence suggests urgency. Delinquency notice, hearing notice, payment made. Now here's the legal distinction. Failure to pay court-ordered fines can trigger contempt of court. New felony charges can trigger probation revocation. That explains why the hearing was structured with both components. But if the fine has now been paid, the contempt issue may be less severe, or at least partially resolved. However, the felony charges remain, and those are far more significant in terms of probation status. So why reschedule? There are several possibilities. The defense may have requested a continuance to prepare. The court may want to see how the felony case proceeds. The judge may want additional documentation, or scheduling conflicts may have occurred. What matters most is this. Probation has not been revoked yet, at least not publicly reflected in booking records. Patrick does not appear to be back in custody today, but the issue is not closed. It has been pushed forward, and pushing it forward to March 3rd, just days before the felony case hearing, may signal that the judge wants to see both matters unfold together. That timing could be strategic. If the felony case shows progress, the judge in the probation case may feel more confident making a decision. Or, the court may be giving Patrick one final window before making a revocation ruling. Another key point: probation revocation does not require conviction on the new charges, but judges sometimes wait to see preliminary developments, such as evidence strength or bond status, before activating a suspended sentence. Now let's be clear. The absence of an arrest record today does not mean the situation improved. It means it's unresolved. March 3rd becomes the new pressure point, and that date now sits directly in front of the March 6th felony hearing. 2 courtrooms. Same week. High stakes. If probation is revoked on March 3rd, Patrick could be taken into custody before his March 6th felony appearance. If probation is continued, he may remain out while both cases move forward. Either way, the window of uncertainty has been extended. This is not over. It's delayed. And sometimes delay signals caution. When a probation revocation hearing is pushed instead of decided, it usually means one thing: the judge wants more information. Courts do not reschedule lightly, especially in matters involving suspended sentences. So when Patrick Roark's revocation and contempt hearing rolled forward to March 3rd, just days before his March 6th felony court date, that alignment likely wasn't accidental. Let's break down what could be happening behind the scenes. First, the judge may be weighing whether to let the felony case develop slightly before activating the suspended sentence. Remember, probation revocation does not require a conviction. The court only needs to determine that a violation occurred. However, when multiple felony charges are involved, reportedly 11, judges sometimes prefer to see preliminary steps in the felony case. Has formal indictment occurred? Has bond been addressed? Is there early evidence discussion? Is there potential dismissal on any counts? Even small movements in the felony case can influence how a probation judge views the seriousness and credibility of the alleged violation. Now consider timing. March 3rd, probation revocation and contempt. March 6th, felony case hearing. That 3-day gap could allow Judge Keith Compton to see the direction of the felony proceedings before finalizing any probation decision. Alternatively, it may allow coordination between courts. Even though different judges preside over separate cases, the judicial system in a single county operates within a shared structure. Information flows. Records are visible. Outcomes in one courtroom are rarely invisible to another. There's also the defense angle. Patrick's attorney may have requested the continuance strategically. If the fine was paid on February 11th, immediately after the hearing notice was served, that resolves at least part of the contempt issue. That payment reduces one argument the state might have relied on. But the felony charges remain the central issue. The defense may want time to review charging documents, evaluate probable cause statements, or prepare arguments that the new charges are weak or unproven. Emphasize that there has been no conviction. By aligning the revocation hearing with the felony timeline, the defense may be hoping to argue, "Your Honor, the felony matter is still developing. It would be premature to revoke probation before that case is evaluated further." That argument does not guarantee success, but it's legally sound. Another possibility is procedural congestion. Court dockets can be crowded. If testimony or documentation was incomplete at the first hearing date, the judge may have preferred to reset the matter rather than rule prematurely. Now let's talk about what this delay means practically. The suspended 1-year sentence from July 21st, 2025 remains in effect but inactive. Patrick is not currently in custody based on available booking records. That means probation has not yet been revoked. But it also means probation is hanging in limbo. And limbo can be more unpredictable than immediate consequences, because now everything depends on March. If on March 3rd the judge determines that the felony charges constitute a substantial probation violation, revocation could happen immediately. If probation is revoked that day, Patrick could be taken into custody before even attending the March 6 felony hearing, potentially appearing at that proceeding from jail. That changes optics significantly. Appearing in custody can influence perception, even though legally it should not impact presumption of innocence. Judges are human. Context matters. Now let's revisit the delinquency notice served on January 22, 2026. That detail is important. Patrick was arrested on the felony case January 16th. While in custody, he was served a notice of delinquency on January 22nd. The next day, January 23rd, he bonded out. On February 10th, he received notice of the probation revocation hearing. On February 11th, he paid the $882.37 fine in full. That sequence suggests the delinquency likely triggered the contempt component of the hearing. But because the fine is now paid, the contempt argument may be weakened. Courts generally view compliance, even late compliance, as a mitigating factor. However, paying a fine does not erase new felony allegations. That's why the revocation portion is likely centered on the new charges, not the money. Another factor to consider is judicial patience. When probation is unsupervised, the expectation is simple: avoid legal trouble. 11 felony charges during that probation period are difficult for any judge to ignore. The delay does not signal leniency. It signals caution. And sometimes caution precedes firm decisions. There is also the possibility that the court wants the probation revocation to occur closer to a substantive development in the felony case, such as indictment or plea negotiation. If a plea deal is reached in the felony case, that could directly influence the revocation outcome. For example, if Patrick pleads guilty to reduced charges before March 3rd, the probation judge may treat that differently than if charges are dismissed or weakened. If the felony case appears shaky, the judge may hesitate to impose maximum probation consequences prematurely. In short, March becomes pivotal. 2 courtrooms in the same week. 2 different judges. 2 separate decisions. 1 overlapping reality. Now zoom out. The absence of an arrest record today should not be interpreted as resolution. It is procedural breathing room. The system has not cleared him. The system has not punished him yet either. It has paused, and pauses in legal proceedings often indicate complexity. Probation revocation is rarely automatic. Felony charges are rarely simple. By scheduling both matters in early March, the court may be positioning itself to assess the broader picture rather than reacting in isolation. For Patrick, that means continued uncertainty. For observers, it means patience. And for the court, it means the suspended sentence from July 2025 remains a live possibility. March 3rd is no longer just another date on the calendar. It's the hinge. Because whatever happens in that probation revocation and contempt hearing will shape what happens 3 days later, and possibly the rest of the year. Let's walk through the realistic outcomes. There are 3 primary paths Judge Keith Compton could take on March 3rd. Outcome 1. Full revocation. This is the most serious scenario. If the judge determines that the 11 new felony charges constitute a substantial violation of probation, he can revoke probation entirely and activate the 1-year suspended sentence imposed on July 21, 2025. That would mean Patrick begins serving the remainder of that 1-year term immediately. He could be taken into custody in the courtroom. No delay. No second hearing. No grace period. If that happens on March 3rd, Patrick would likely appear at the March 6 felony hearing from jail. Now, legally, being in custody should not affect the presumption of innocence in the felony case. But practically, it changes the atmosphere. A defendant in custody enters court differently than a defendant who walks in on bond. It can influence negotiations. It can influence scheduling. It can influence the urgency of plea discussions. It also shifts leverage. When someone is out on bond, they can work freely with counsel, assist in preparing defense, and demonstrate stability. When someone is in custody, the dynamic tightens. prosecutors may feel less pressure to negotiate quickly. Defense counsel may push harder for resolution to avoid prolonged incarceration. And here's another key factor. If probation is revoked, the time served on that sentence does not automatically erase exposure in the felony case. If later convicted on the felony charges, a separate sentence could be imposed. The felony judge would then decide whether that sentence runs concurrently at the same time as the probation sentence, or consecutively after the probation sentence ends. That distinction could mean months versus years of difference in total exposure. Outcome 2. Partial revocation. Judges sometimes take a middle ground approach. Instead of activating the full suspended year, the court could impose a shorter period of incarceration, for example, 30, 60, or 90 days, and then reinstate probation afterward. This sends a message of seriousness without imposing the maximum consequence. If this happens on March 3rd, Patrick may serve a brief jail period and then return to probation status, potentially under stricter conditions. However, this approach becomes less common when multiple felony charges are pending. 11 felony charges are difficult to characterize as minor. Still, partial revocation is within the judge's discretion. Outcome 3. Continuation of probation. This is the least severe outcome. The judge could determine that, since the felony charges have not resulted in conviction, it is premature to revoke probation. He could continue probation, possibly with added conditions. For example, supervised probation instead of unsupervised, travel restrictions, or mandatory reporting, regular compliance checks. This outcome would allow Patrick to remain out of jail while the felony case proceeds. But let's be clear. Continuation does not eliminate risk. If the felony case results in conviction later, probation could still be revoked at that time, as long as the probation period remains active. The suspended sentence from July 21, 2025 does not disappear until July 21, 2026. So even if March 3rd passes without revocation, the probation issue stays alive. Now let's address the contempt component. Because the fine of $882.37 was paid on February 11th, the contempt issue tied to delinquency may be less significant. Judges generally view late payment more favorably than non-payment. However, if contempt involves something beyond unpaid fines, such as failure to comply with other court orders, it could still result in additional jail time. Contempt penalties can reach up to 6 months. That could be imposed separately from probation consequences. Now let's zoom out. The alignment of March 3rd and March 6th is strategic. 3 days apart. That means the probation judge may want to see immediate developments in the felony case before making final long-term decisions. Or he may rule first and allow the felony court to proceed under whatever status exists at that time. There's also a psychological factor. Returning to the same judge who granted probation less than a year ago carries weight. Probation is not automatic. It is discretionary leniency. If a defendant returns facing new serious allegations, judges sometimes feel compelled to reinforce the authority of their original order. But judges also consider fairness. Revoking probation before a felony case is adjudicated can feel harsh if charges later collapse. So March 3rd may reflect a balancing act. Community safety versus procedural caution. Judicial authority versus presumption of innocence. Leniency versus accountability. The absence of an arrest record from the original hearing date suggests the court chose not to act immediately. That could mean the judge wanted additional documentation. The defense requested more time. The court preferred to align decisions closer to the felony case. Or procedural scheduling required adjustment. Whatever the reason, March now becomes decisive. If probation is revoked on March 3rd, the legal tone for March 6th shifts immediately. If probation continues, Patrick walks into the felony hearing still technically compliant, though under heavy scrutiny. And if partial revocation occurs, the week becomes even more complex. 2 courtrooms, 2 rulings, 1 overlapping narrative. The legal system rarely moves in dramatic bursts. It moves in steps. March 3rd is a step. March 6th is another. Together, they could determine whether the suspended sentence from July 2025 becomes real time or remains hanging over him a little longer. As March 3rd approaches, the real movement may not be happening in the courtroom. It may be happening behind closed doors. Because when 2 major hearings fall within the same week, probation revocation on Tuesday and 11 felony charges on Friday, strategy becomes everything. Let's start with the defense side. Patrick's attorney is looking at 2 separate but connected legal tracks. The probation case in front of Judge Keith Compton. The felony case in front of a different judge 3 days later. Even though these are separate proceedings, the facts overlap. The probation revocation hinges largely on the existence of the felony charges. The felony case stands on its own merits, evidence, witnesses, probable cause. So what might the defense strategy look like? First, delay where beneficial. The fact that the original probation hearing did not result in immediate revocation suggests either the defense requested time or the judge wanted more clarity. Time can be valuable. It allows counsel to review charging documents thoroughly, evaluate weaknesses in the state's case, assess whether all 11 charges are equally strong, prepare mitigation arguments. If the defense can argue that the felony case is unstable, perhaps overcharged, exaggerated, or built on questionable evidence, they may use that uncertainty to push against revocation. The core argument would be simple. Your Honor, these are allegations, not convictions. It would be unjust to impose the suspended sentence before this case is properly evaluated. That argument becomes stronger if, by March 3rd, there are signs that the felony case is evolving, such as potential dismissal of counts, amended charges, or negotiation discussions. Now let's look at the prosecution side. Prosecutors often approach probation revocation differently than felony trials. In a felony trial, they must prepare for the burden of proof beyond a reasonable doubt. In a revocation hearing, they need far less. They only need to convince the judge that probation conditions were violated. And new felony charges, especially multiple ones, are powerful leverage. The state may argue, probation required law-abiding conduct. Being charged with 11 felonies reflects serious alleged misconduct. Community safety demands revocation. The suspended sentence should now be activated. They may not even need to delve deeply into the felony evidence. The existence of the charges themselves may be sufficient to persuade the judge. Now here's where strategy gets led. If the prosecution believes the felony case is strong, they may prefer probation revocation first. Why? Because incarceration changes dynamics. A defendant in custody may feel increased pressure to resolve the felony case. Negotiation leverage can shift. On the other hand, if the felony case is complex or requires extended litigation, prosecutors may not oppose a short continuance in the probation matter until more clarity emerges. Every side calculates risk differently. Another critical factor is optics. Judges do not operate in isolation. When one judge sees that another judge has revoked probation based on the same underlying conduct, it can influence perception. Likewise, if probation continues despite serious charges, the felony judge may interpret that as a signal, though they are not bound by it. Now let's consider what might happen if there are plea discussions underway in the felony case before March 3rd. It's possible that defense counsel and prosecutors are already communicating. If there is any indication that a plea agreement could resolve the felony charges, even partially, that could directly impact the probation hearing. For example, If a plea to reduce charges is imminent, the probation judge may consider that in determining whether to activate the full suspended year. If dismissal of certain counts is likely, that weakens the state's narrative of severe violation. This is why the 3-day gap between March 3rd and March 6th is significant. It compresses decision-making. It increases pressure. It forces coordination. Now let's not forget the contempt issue. While the fine of $882.37 has been paid, contempt may still technically be on the docket. If contempt was tied solely to non-payment, that argument weakens considerably after payment. Judges often consider compliance, even late compliance, as mitigating. But if contempt involves broader disobedience of court orders, the state could still pursue penalties. That said, the major weight likely rests on the felony-related probation issue. Another dimension here is credibility. Probation hearings are as much about perception as paperwork. How the defendant presents, how the attorney argues, how respectfully the matter is handled. Returning to the same judge who granted probation less than a year ago carries emotional undertones. The court extended trust. The court will now evaluate whether that trust was justified. Defense counsel may emphasize positive factors. No missed court appearances. Payment of fines once notified. No prior probation violations before this incident. Community ties. Prosecutors may counter with the seriousness of the alleged felonies. The timing, occurring during probation. The need for deterrence. Behind the scenes, both sides are likely preparing contingencies. If probation is revoked, what's next? If probation continues, how does that influence Friday's felony hearing? If partial revocation is imposed, how does that alter negotiation strategy? The week of March 3rd is shaping up to be pivotal. And here's the most important point. The absence of an arrest record after the original hearing date does not indicate resolution. It indicates positioning. The system is aligning pieces. The judge may want to evaluate the broader context before making a final probation decision. Or the defense may have successfully requested more time to prepare. Either way, the legal chessboard is set. Tuesday, probation revocation and contempt. Friday, 11 felony charges. 2 separate rulings. 1 interconnected outcome. When court dates stack on top of each other like this, the legal analysis is only half the story. The other half is pressure. Because the week of March 3rd isn't just 2 hearings on a calendar. It's a convergence point. Tuesday could determine whether Patrick Roark walks freely into Friday's felony hearing or is escorted in from custody. That difference matters, not just legally, psychologically. When someone lives under a suspended sentence, it's like a clock running in the background. It doesn't tick loudly every day. But when a probation revocation hearing appears, the clock becomes impossible to ignore. On July 21, 2025, the court gave him 1 year of unsupervised probation and suspended a 1-year jail sentence. That suspension doesn't fade quietly. It stays active until July 21, 2026. It is conditional freedom, and conditional freedom always carries weight. Now, with March 3rd approaching, that suspended sentence is back in focus. The hearing before Keith Compton will determine whether the clock continues running quietly or stops abruptly. If probation is revoked, custody begins immediately. If probation continues, uncertainty continues. If partial revocation occurs, consequences begin in measured form. But none of those outcomes erase the felony case schedule for March 6th. That case stands independently. 11 felony charges are not minor allegations. They are serious. And regardless of the probation outcome, the felony case carries its own potential exposure. This is what makes the week so pivotal. It's not just one judge. It's 2. It's not just one decision. It's overlapping decisions. And here's something people often underestimate. Legal uncertainty is its own consequence. Waiting for a ruling. preparing for worst-case scenarios, not knowing whether you will sleep at home next week or in a jail cell. That strain exists before any sentence is imposed. From a structural standpoint, the system is doing what it's designed to do. When someone on probation faces new charges, the court must respond. When fines go delinquent, notices are served. When compliance occurs late, the record reflects it. Everything becomes documented. Everything becomes visible to the court. The fact that the fine of $882.37 was paid after the delinquency notice may mitigate the contempt angle, but it does not erase the timeline. Arrest on January 16th. Delinquency notice served January 22nd. Bond on January 23rd. Hearing notice February 10th. Payment February 11th. That sequence shows responsiveness, but it also shows reaction. And courts notice timing. Now consider optics heading into March. If probation is revoked Tuesday, Friday's felony hearing begins under a different tone. If probation continues, Friday begins with conditional trust still intact. If probation is partially revoked, both judges are navigating layered consequences. And there's another factor people sometimes overlook. Judges are not isolated decision-makers. They operate within a system that values consistency. If one courtroom imposes incarceration based on alleged conduct, another courtroom will be aware of that fact, even if they are not bound by it. Momentum can build, or restraint can build. That's why March 3rd is not just procedural, it's directional. It sets the tone. The absence of an arrest record after the original hearing date was not closure. It was delay. And delay in the legal system is rarely accidental. It may signal the judge wants to observe developments in the felony case. The defense requested time to prepare. The court wants to evaluate documentation more thoroughly. Whatever the reason, the issue remains open. And open issues are often more volatile than resolved ones. Let's talk about the human side again. When someone returns to the same judge who granted them probation less than a year ago, there's an unspoken narrative in the room. Second chances, expectations, accountability. Probation is not punishment-free. It is punishment deferred. Deferred punishment becomes immediate if conditions are violated. And when 11 felony charges enter that equation, the risk increases. But risk is not certainty. That's the key distinction right now. As of today, there is no visible booking record indicating immediate incarceration. A new hearing date is set for March 3rd. The felony case remains scheduled for March 6th. Everything is in motion. Nothing is final. The next few days are not about commentary. They are about rulings. If probation is revoked, the suspended year becomes real. If it's continued, the clock keeps running. If partial revocation occurs, consequences begin in stages. And Friday still waits. 2 hearings. 1 week. Multiple possible paths. Legal systems often move quietly until they don't. March 3rd could be quiet, or it could be decisive. But by the end of that week, there will be clarity. For now, what exists is tension. And tension in the legal world often precedes resolution. If you've been following this case closely, share your thoughts below, respectfully. What do you think happens on March 3rd? Full revocation? Partial? Continuation? We'll know soon enough. Until then, the suspended sentence remains suspended. And the week ahead carries more weight than any update so far. Thank you for watching this video. Click here to watch another video that might interest you.